Did the Post Office attempt to change the law to make it easier to prosecute the sub-postmasters? Yes, they did, and let me explain how. Um, I've mentioned in another video about something called Section 69 of the Police and Criminal Evidence Act 1984. And what that introduced was the idea that before any evidence produced by computers can be admissible, the party wishing to rely on that evidence, and this actually applied both to prosecution and defence, they had to put in evidence that the computer system was working properly and that the material it produced was reliable. However, as computers started getting more and more complex and lots of more statements were produced by computers, people did start to say this is getting to be quite burdensome. So an organisation called the Law Commission put out a consultation document. The Law Commission is a non-partisan body that just supervises and keeps an eye on legislation and makes recommendations. It doesn't so much argue for changes to the substantive law. What it tries to do is say, well, Parliament's passed this law. Is it doing what Parliament intended, and do people understand it, and are there any problems or unforeseen sort of consequences? So the Law Commission put out a consultation paper on this. It was a really lengthy one, actually. It was like about 180 pages. And they said, here's some issues that people have identified. Before we start recommending a change in the law, has anybody got anything to say about this? And people put in submissions. Now, a lot of the submissions, and especially one they relied on a lot, come from academics, professors of law who look at sort of how this is working in theory and practice. And, they produce all these fantastic papers. However, anybody can submit a response. And you'll see in the report, there's a section there saying they had a number of responses in favour of abolishing that requirement and going back to the old common law position, which was we just presume that any mechanical device, including computers, works properly. You see, there's like HMRC and the CPS in there, but when we go down, our old friend, the Post Office. Now, bearing in mind what's happened since, you might be wondering what they actually put in as submissions. And some people also wondered that, and they put in a Freedom of Information request. But this was the Post Office's response. We do not have such a document. Now, somebody more cynical and sceptical than I might say they are proving to be really, really bad at remembering that they have documents, because we've discussed about the disclosure both in the civil and criminal cases and now in the inquiry, where yet again they're in trouble for not fulfilling their disclosure obligations. But they came back and said, nope, sorry, don't have any such document. However, luckily, the Law Commission did keep copies of everything, and I managed to get hold of their submissions. They actually put in two. One was a relatively short one paragraph submission, just saying, yes, it would be great to get rid of this because it causes all sorts of problems. And then there was a more substantive response, which I am going to read for you. This office, inter alia, prosecutes offenders who have committed offences against the Post Office. The offenders can be employees, sub-postmasters, or members of the public. Typical offences prosecuted by this office include theft of money from the till or false accounting by counter-clerks or sub-postmasters, and willful delay and stroke or theft of mail by Royal Mail staff. This list of offences is not exhaustive. A senior lawyer in this office has reviewed the above-mentioned consultation paper. This office welcomes your proposals, especially in relation to repealing Section 69 of the Police and Criminal Evidence Act 1984. And just to be myself for a second, like I say, that's the one that said you've got to prove your computer systems are working before you put any evidence in arising from them. And then they go on, and repealing the discretionary provisions of Sections 25 and 26 of the Criminal Evidence Act 1988. And just to be me again, those sections basically say that even if everything is admissible under the current law, the judge still has a discretion to exclude that evidence in the interests of justice. So it keeps open this idea, that a judge can say, I don't care if you've ticked all the boxes, I just don't think this is right and it shouldn't go in. And it carries on, with regard to the present potential evidential problems caused by Section 69 of the Police and Criminal Evidence Act, a large number of sub-postmasters now complete their cash accounts and other accounting records by using a computer. The sub-postmaster is often the only person working in the sub-post office, or the only person who uses the computer. In the event of the sub-postmaster being prosecuted for theft or false accounting, the post office may need to rely upon the computerized accounting records. The submost postmaster is frequently the only person who can give the evidence required by Section 69 of PACE. In the absence of admissions or other direct evidence, the post office may not be able to prove the case solely on the ground of being unable to satisfy the technical requirements of Section 69 of the Police and Criminal Evidence Act 1984. So there you see, they were basically saying, look, we prosecute a lot of sub-postmasters, and it seems like we're planning to prosecute a lot more of them. But if we've got to prove this system is working, the only people who can give evidence about the operation of the Horizon computer system are the sub-postmasters. And, they're probably not going to say it's working, are they, by definition? So they asked for that Section 69 to be repealed, and it subsequently was. The Criminal Evidence Act bits actually still exist, because it was a bit of a long stretch saying we'd like you to get rid of any judicial discretion to exclude evidence. We just want to be able to admit anything we want unchallenged. But there you go. So yeah, interestingly, that new legislation came in 1999. And we saw that, a lot of these prosecutions then really picked up after that, because all of a sudden their job was a lot easier because they didn't have to put in the evidence it works. Now, Dan did an excellent video on primary and second disclosure, which was really kind of him actually, because I'd meant to mention it in my previous video and then I forgot. So I mentioned primary and second disclosure, but they never actually said what it was. But yeah, in these prosecutions, I mean, a big problem was it shifted the burden back onto the defendant, and it was for them to say, right, you need to show that this system isn't working. Now, obviously, the material to show it isn't working are all things like the error logs and the reports and other complaints, which were all in the hand of the post office. Now, had the post office complied with their disclosure obligations, and we've heard in the inquiry that when they were preparing statements from the people, the IT people of the post office, they were being told to remove anything in their statement that said, actually, no, there are problems to this system. There are bugs. We have had complaints. So part of the problem was that with the removal of, that section and the requirement to prove the system was working, the onus was back on the postmaster to show it wasn't. And in breach of their disclosure obligations, the post office was not disclosing the material they needed to be able to do that. So there you go. Maybe there'll be another Law Commission consultation on this. Actually, consultation went into lots of things about hearsay generally. Maybe one day I'll do another video on it because it was quite interesting. But there you go. Hopefully you found that, as always, vaguely useful, vaguely interesting, marginally accurate. If you did so, then please consider clicking, liking, sharing, subscribing, and also all that YouTube stuff. And now I'll go away and pull some faces. I'm really sorry about this, especially for such a serious subject, but literally the YouTube algorithm, the goofier the face, the better it is.